Illinois has one of the most complex tenant screening environments in the Midwest, driven by a combination of state-level reforms and Chicago's extensive local ordinances that impose some of the most restrictive screening requirements in the country. If you're screening tenants in Illinois, what rules apply depends dramatically on whether your property is in Chicago or elsewhere in the state. The governing framework includes the Illinois Human Rights Act, the Illinois Rental Property Utility Service Act, FCRA, and, for Chicago properties, the Chicago Fair Notice and Tenant Protection Ordinance, and the Chicago Residential Landlord and Tenant Ordinance. Let's start with application fees. Illinois does not have a statewide cap on application fees. There is no state statute limiting what landlords can charge for screening outside of Chicago. Landlords in downstate Illinois can charge whatever they determine is reasonable. Chicago is a different story. Chicago has enacted specific provisions governing application fees. Under the Chicago Residential Landlord and Tenant Ordinance, landlords in Chicago must comply with fee disclosure requirements and cannot charge fees that are unreasonable or exceed the actual cost of screening. Chicago landlords must provide applicants with written notice of the screening criteria and fee amounts before collecting the fee. If the landlord doesn't actually conduct the screening, the fee must be refunded. Most Illinois landlords outside Chicago charge between $25 and $50 per applicant. Chicago landlords should keep fees at or near actual screening costs and maintain documentation of those costs. Criminal history screening in Illinois is where the regulatory landscape becomes extremely complex, because Chicago has enacted one of the most restrictive criminal history screening laws for housing in the country. At the state level, Illinois does not have a comprehensive statewide ban-the-box housing law with the detailed procedural framework found in places like Washington, D.C. or Minneapolis. However, the state has enacted reforms that affect how criminal records can be used. Illinois expanded its expungement and sealing provisions significantly. Under the Criminal Identification Act, found in 20 ILCS 2630, more offenses are eligible for sealing and expungement than in previous years. Illinois also enacted automatic expungement provisions for certain cannabis-related offenses following legalization. Landlords cannot consider sealed or expunged records in screening decisions. Illinois legalized recreational marijuana through the Cannabis Regulation and Tax Act. The Act includes specific protections. Landlords cannot discriminate against applicants based on legal cannabis use, while landlords can still prohibit marijuana use on the premises through lease provisions. Using historical marijuana records for conduct that's now legal as a basis for denial creates risk. The Illinois Human Rights Act, found in 775 ILCS 5, prohibits discrimination in real estate transactions and has been interpreted to restrict the use of criminal history in ways that create disparate impact on protected classes. The Illinois Department of Human Rights investigates complaints and takes enforcement action. Chicago enacted the Just Housing Amendment to the Chicago Fair Notice and Tenant Protection Ordinance, one of the most restrictive criminal history screening laws for housing in the nation. Under the Just Housing Amendment, Chicago landlords face comprehensive restrictions on criminal history screening. Chicago landlords cannot inquire about or consider an applicant's criminal history until after making a conditional offer of housing. The initial application cannot contain any questions about criminal background. The landlord must first evaluate the applicant on all other criteria: income, credit, rental history, references, and extend a conditional offer before accessing criminal records. After making a conditional offer, the landlord can conduct a criminal background check, but significant restrictions apply. Landlords cannot consider arrest records that did not result in conviction. Landlords cannot consider sealed, expunged, or pardoned records. Landlords cannot consider juvenile records. Landlords cannot consider convictions for offenses that have been decriminalized, including marijuana offenses. And Chicago imposes specific look-back period limitations that restrict how far back landlords can consider convictions. When a Chicago landlord considers criminal history after a conditional offer, a detailed individualized assessment is required. The assessment must evaluate the nature and severity of the offense, the time elapsed since the conviction, the applicant's age at the time, evidence of rehabilitation, the nature of the housing being sought, and whether the applicant has any supplemental information to provide. The landlord must give the applicant an opportunity to respond with mitigating information before making a final decision. If the landlord withdraws the conditional offer based on criminal history, the landlord must provide written notice that specifically identifies the conviction, explains how the individualized assessment factors were applied, and informs the applicant of their right to dispute the decision. The notice requirements are detailed and specific. The penalties for violating Chicago's Just Housing Amendment are significant. The Chicago Commission on Human Relations enforces the ordinance, and violations can result in fines of up to $1,000 per violation for the first offense, up to $5,000 for subsequent offenses, compensatory damages, attorney's fees, and mandatory fair housing training. Repeat violators face escalating penalties. Outside Chicago, the criminal history screening landscape is more permissive. Springfield, Peoria, Rockford, and downstate communities generally operate under state law without additional local restrictions. However, some collar counties and suburbs have discussed additional protections, and landlords in the Chicago suburbs should monitor local developments. Evanston, adjacent to Chicago, and Oak Park have enacted their own tenant protection measures and have been among the most progressive municipalities in Illinois on housing issues. Landlords in these communities should verify current local requirements. Cook County enacted the Just Housing Amendment at the county level, extending Chicago-style criminal history screening restrictions to unincorporated areas of Cook County. Landlords operating in unincorporated Cook County must comply with the county's restrictions, which mirror Chicago's provisions. HUD's 2016 guidance on criminal history and disparate impact applies statewide. Illinois' diverse population, particularly in Chicago, the collar counties, and cities like Rockford, Springfield, and Peoria, means that criminal history policies that disproportionately affect minority applicants face significant scrutiny. Source of income protection in Illinois varies by jurisdiction. Illinois does not have a comprehensive statewide source of income protection law that explicitly prohibits discrimination against voucher holders in all jurisdictions. However, Chicago has a strong source of income protection under the Chicago Human Rights Ordinance. Chicago landlords cannot discriminate against applicants based on their source of income, including housing choice vouchers, Social Security, disability payments, and other government assistance. The Chicago Commission on Human Relations enforces this protection actively. Fair housing testing is conducted regularly, and landlords who state they don't accept vouchers face enforcement action. Cook County has also enacted source of income protections that apply in unincorporated areas. Evanston, Oak Park, and several other Chicago area municipalities have their own source of income protections. Urbana, home to the University of Illinois, has enacted source of income protections. Champaign has discussed similar measures. Outside of protected jurisdictions, source of income discrimination is not prohibited. Landlords in downstate Illinois generally have discretion over whether to accept voucher-paying applicants. For credit reports, Illinois follows FCRA requirements for permissible purpose and written consent. The adverse action process follows both FCRA and any additional local notification requirements, particularly in Chicago, where the individualized assessment and notification procedures add substantial requirements beyond the federal baseline. Illinois' fair housing protections under the Illinois Human Rights Act are broader than the federal baseline. Protected categories include race, color, religion, national origin, sex, sexual orientation, gender identity, disability, familial status, marital status, age, ancestry, military status, unfavorable discharge from military service, and order of protection status. The breadth of these protections is substantial. The unfavorable discharge from military service protection is unusual. It means landlords cannot discriminate against applicants who received a less than honorable military discharge. While this rarely arises in screening, it reflects the comprehensiveness of Illinois' framework. The order of protection status means landlords cannot discriminate against applicants who have obtained an order of protection as victims of domestic violence, stalking, or harassment. This protection ensures that victims who have taken legal steps to protect themselves aren't penalized in the housing market. Chicago's Human Rights Ordinance adds even more protected categories, including source of income, gender identity, parental status, and housing status. Chicago's protections are among the broadest of any city in the country. The Illinois Department of Human Rights investigates statewide complaints. The Chicago Commission on Human Relations handles complaints within Chicago. Both agencies have active enforcement programs. From a practical standpoint, Illinois has one of the largest and most diverse rental markets in the Midwest, dominated by the Chicago metro, but with significant secondary markets. Chicago is the third largest city in the country and has an enormous rental market. The economy is driven by financial services, the CME Group, the Chicago Board Options Exchange, and major banks, technology, a growing tech sector centered in the West Loop River North, and Fulton Market, healthcare, including Northwestern Medicine, Rush University Medical Center, and the University of Chicago Medical Center, higher education, the University of Chicago, Northwestern, DePaul, Loyola, UIC, and dozens of others, manufacturing, logistics, and government. Chicago's rental market is massive and diverse, ranging from luxury high-rises along the lakefront to affordable housing across the south and west sides. Chicago's screening environment is among the most restrictive in the nation. The Just Housing Amendment's criminal history restrictions, source of income protections, broad fair housing categories, and detailed procedural requirements create a screening process that's fundamentally different from the rest of Illinois. Chicago landlords must invest significant effort in compliance, building the two-stage screening process, documenting individualized assessments, providing detailed notifications, and training staff on the comprehensive requirements. Chicago's neighborhoods have dramatically different rental dynamics. The Loop, River North, Lincoln Park, Lakeview, and Wicker Park command premium rents. Logan Square, Pilsen, Bridgeport, and Hyde Park have experienced gentrification and rising rents. The south and west sides have more affordable rents and higher concentrations of tenants receiving housing assistance. The Chicago suburbs, including Evanston, Oak Park, Naperville, Schaumburg, Arlington Heights, and the broader Collar counties, have strong markets driven by corporate employment, excellent school systems, and transportation access. Properties in Cook County's unincorporated areas are subject to Cook County's Just Housing Amendment. Properties in DuPage, Lake, Will, Kane, and McHenry counties generally operate under state law without county-level criminal history restrictions, but landlords should verify local requirements. Springfield, the state capital, has a moderate market driven by state government, healthcare, including Memorial Health System and HSHS St. John's, and education. The market is affordable with steady demand. Peoria has a moderate market driven by Caterpillar's headquarters, though the company has relocated some operations, healthcare, and manufacturing. Rockford has an affordable market that has faced economic challenges. Champaign-Urbana, home to the University of Illinois, has a tight student market with Urbana's source of income protections adding a regulatory layer. Bloomington-Normal, home to Illinois State University and State Farm's headquarters, has a moderate market. The Quad Cities, including Rock Island and Moline, have markets influenced by manufacturing and the Rock Island Arsenal. The military presence in Illinois includes Scott Air Force Base near Belleville, home to U.S. Transportation Command, which generates significant military rental demand in the Metro East area across the Mississippi from St. Louis. Great Lakes Naval Station north of Chicago is the Navy's only boot camp and generates some rental demand in the North Shore communities. Landlords near these installations should understand military income documentation. One critical best practice for Illinois landlords: determine immediately whether your property is in Chicago, unincorporated Cook County, or another jurisdiction with local screening restrictions. The regulatory difference between Chicago and downstate Illinois is enormous. If your property is in Chicago or Cook County, build your entire screening workflow around the Just Housing Amendment. If your property is downstate, state law and FCRA are your primary frameworks, but still maintain documented criteria and consistent application. Another critical best practice: for Chicago landlords, implement the two-stage screening process required by the Just Housing Amendment. Remove all criminal history questions from your initial application. Evaluate all non-criminal criteria first. make a conditional offer to qualified applicants. Only then conduct the criminal background check. Document your individualized assessment thoroughly for every applicant whose criminal history you consider. Provide the required written notices with specific content when withdrawing a conditional offer. Train every person involved in the application process on these procedures. A single procedural misstep can trigger a commission complaint. A third best practice: for Chicago landlords, never state in any form that you don't accept vouchers or government assistance. Chicago's source of income protection is actively tested and enforced. Remove discriminatory language from all listings, websites, and communications. Train everyone who handles inquiries that source of income discrimination is prohibited. The Commission on Human Relations regularly investigates source of income complaints. For landlords operating in both Chicago and downstate locations, maintain completely separate screening procedures. Chicago's requirements don't apply downstate, and downstate's permissive framework doesn't apply in Chicago. Having clearly documented location-specific procedures prevents compliance errors. Illinois does not have a statewide statutory cap on security deposits for units with 5 or more units, but Chicago does limit deposits. Under the Chicago RLTO, the security deposit is limited to 1.5 months' rent. The deposit must be held in a federally insured interest-bearing account, and the landlord must pay interest annually. Statewide, for properties with 25 or more units, deposits must be held in a federally insured interest-bearing account, and interest must be paid annually. Deposits must be returned within 30 to 45 days, depending on the specific provisions. The deposit limitations in Chicago make thorough compliance screening essential. Your financial protection is capped. For the complete guide to Illinois tenant screening laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our tenant screening law series.